Hello and welcome to Chetan Bharat Learning, and this class is for current affairs or polity for the previous week. So we're going to cover current affairs from 4th of December all the way to 10th of December. All right, so not much really happened in terms of polity in the previous week because the democratic space news was generally just occupied by agricultural protests that are happening and some other items which was not directly related to your UPSC syllabus for polity. So we are going to take this opportunity to have to develop a better understanding of two issues. All right, the first is agricultural laws from a very polity perspective. All right, so what is the impact of these agricultural laws on the federal polity of our nation? All right, so we're going to understand that. So if you come across a question on agricultural laws and the constitutional structure, you could use the content that we're going to deliver today. Or if you come across an essay, there's a bunch of stuff that you can use. And this is also true for the second topic that we're going to do, Supreme Court on hate speech. We're going to try and understand the theoretical background of hate speech and delineate hate speech from free speech. All right, so let's begin. You know that there are agricultural laws in place. If you don't know that, please switch on your TV and you know that. And there's a farmers' protest raging around Delhi. So the economic part of it, Raghav sir has covered beautifully. I have developed my understanding on the economic consequences of these farmers' laws, of these agricultural laws from Raghav sir. I hope you watch that video very carefully, and he is going to touch upon the same topic from a purely agricultural perspective, from a purely economic perspective also. The brief for today's class is going to be how the interface between these laws and the political structure of our country. All right, so let's begin. Let's first quickly get a glance through the three legislations that have been pushed through Parliament. All right, the brief again is not to give you a detailed idea of these laws, just quickly revise what these are. All right, so the names are quite a mouthful. The first legislation is Farmers Produce Trade and Commerce Promotion and Facilitation Act of 2020. You'll be served well if you just remember that it's the Farmers Produce Act. All right, just call it that. It will suffice even in your answers. All right, so what it does is that it allows trade of farmers' produce outside the physical boundaries of the area notified under the APMC laws, the state APMC laws. All right, so as Raghav sir would have discussed this with you, I'm just going to quickly help you revise. All right, so every state government creates an area called the state APMC Mandi, where the first sale of a farmer's produce of notified items, for example, your wheat, your rice, or these are notified items, and these notified items also vary from state to state. Of these notified items, this first sale of these happens within the premises of these areas notified under the state agricultural laws, the state APMC Acts. All right. So what this law does is that it says to the farmer that now the area outside of the notified area is free for trade also. So you can sell your produce even outside the area notified by the state government. All right. So it will prevail over the state APMC Acts. I hope that's clear to you. The interesting part here is that the Act prohibits state governments and APMCs from levying any market fee or other kinds of fees that the state government levies on mandis. All right, we're going to get to those other kinds of fee and taxes also. All right, so now earlier what used to happen was that if you needed to buy agricultural produce from a state, you had to go to a state notified mandi for those notified items, and you had to get a license from the state government and pay different kinds of fee, and you had to pay certain amount, right? And then you can buy the produce. Now this legislation cancels out the state government's power to levy any market fees or any other charge for such trade. All right, so the act you would be good enough to remember is that this act does not actually negate the state APMC acts altogether. It just neutralizes its effect. All right, it just says that now the boundary of the area notified by the state APMC Act is not as sacred. All right, that's all it does. Now the next act is again quite a go ahead and name this, the Farmers Empowerment and Protection Agreement on Price Assurance and Farm Services Act 2020. You can just call it the contract law, right? The Farmers Contract Act, all right? The framework for farmers to engage in contract farming comes from this place, all right? So what this act does is that it provides certain model conditions, right? It says, for example, that the agreement would have to be done at this date, right? The prices would have to be pre-decided. What if there is a dispute between the farmer and the contractor, which could be a multinational company, right? So what happens if there is a dispute? It's sort of basic, the basic structure for what an agreement between a farmer and a contractor would look like comes from this law, right? Then it further exempts certain commodities from stockpiling limitations under the Essential Commodities Act, right? But that's not as important. Again, the important bit is it also provides for a 3-level dispute settlement mechanism, all right? Then there is the Essential Commodities Act. The 2020 amendment pretty much allows the central government to regulate the supply of certain food items only under certain specific conditions. All right. So earlier, what used to happen is that whenever there's an abrupt price rise, the central government always had the power to regulate the market, to impose restrictions on how much a particular trader could hold. Right now, even now, the power remains with the central government. However, many items have been removed from the list of items on which the central government could do that, and the conditions under which the central government could do this have been made narrower and narrower. All right, so this is the import of Essential Commodities Act. Now, this act is important for today's class also. We're going to understand the genesis of this act. All right. So now that you have an understanding, or you already had an understanding now that you've revised these 3 laws, the primary question that we're trying to answer today is what is the impact of these laws on federalism? And we're not going to delve very deep into this question, although there is a good scope for that. We're going to try and answer this question from a paper's perspective, all right? So you have an idea of what federalism is, right? You have a basic idea, or if you don't have an idea, you're going to attend the polity lectures and you will sort of acquaint yourself with the basic principles of federalism. In a nutshell, whenever different political entities come together to form a union by giving up a part of their sovereignty and joining forces, it sort of looks like a federation, right? That's what people call a federation. Now, there is a rich variety of political cultures, of political establishments within a federal structure. For example, India is a very different kind of a federal structure, and whether it is one or not is also subject matter of debate. The United States is a recognized, the Constitution itself recognizes itself as a federation. However, there are other entities that can also be a federation, right? For example, do you remember the Maratha Confederacy? You must have come across that term in your modern history, right? Or you will come across that term. Now, the reason why it's a confederacy instead of federation is because the individual units, for example, the leaders of the Pune region or the leaders of the Nagpur region, when they came together against the British, the units, right, they had more powers compared to the Peshwa at the center in the initial stages of their union, right? So that's what we call a confederacy, where the parts outside of the center, where the units are stronger than the center. All right. Now, India, on the other hand, is quite a strong union, right? In fact, the Article 1 of the Constitution uses the word union of states. There is no reference to the term federalism in our Constitution, right? So, the commentators, so the thing that you sort of need to understand is that the makers of our Constitution, our founding fathers, created a structure of government, distributed powers between the union government and the state governments, and then it's the commentators who sort of visualize the Indian polity and give their opinions as to whether it's a federation or not. All right. So someone recently asked me, like within this establishment, someone asked me, is India a quasi federal entity or not? Right. That doesn't matter. You just need to know that that's the opinion of a commentator, and all you need to do is figure out why he or she says so, right? So for example, some commentator would say it's a quasi-federal structure with a centralizing tendency. Some commentator would say it's not a federation at all. Some commentators say that India never was a federation, it's the most unionist structure possible, all right? But one commentator that really matters is the Supreme Court, right? So Supreme Court has sort of wavered between India not being a federation at all to federalism being a basic feature of our constitution, right? So the first case was State of Bengal versus Union of India, where Supreme Court pretty much said that India is not a federation, just look at the provisions, all right? And then in SR Bombay in the 90s, the Supreme Court came around to the fact that federalism is a basic feature of our constitution, all right? So this is just to highlight the variance within the opinions of an institution. So you can imagine, right, the variance that you would find in the opinion of commentators across, right? For example, Louis Tillian would call India an asymmetric federalism, right? So you don't need to know all of that, but you should be aware of the fact that these are just commentators telling you what they feel the Indian constitution is, right? How is the Indian constitution put in practice? How does the Indian constitution put in practice the principle of federalism, right? So what it does basically, the scheme that we've sort of inherited from the Government of India Act of 1935 is that we've created these three lists, all right? There is three buckets also is how you can visualize them. Some matters, some subject matters are a pure domain of the union government. For example, security, right? Union government is bound to defend states from external aggression, right? Communication, right? That's another thing that union government would do, right? Aviation, right? There are some subjects that the union government has. In fact, union government has the most number of subjects, right? 97, right? Then there are some subjects which are the sole domain of the state government, right? The state legislature, which is called the state list, like list 2. Then the interesting part of it is that there is a concurrent list, list 3, all right? There are some issues in list 3 on which the state legislature and the union legislature both can legislate. And if there is a conflict between the laws of these two legislatures, the union legislature and the state legislature, then the union legislature's law would prevail over the state legislature to the extent of the repugnancy, all right? So this is the principle that we've adopted, and it's a very strong it's a principle that really points you in the federal direction, right? It tells you that India is a federation, all right? However, there are some other redeeming features of our constitution that sort of tell you that it's not exactly that much of a federation. But for now, this schema is what you should know or should be aware of, all right? So now let's come to the topic, like let's come to the meat of the subject here. Where does agriculture fall, right? And that's a big issue. Why? Because even now 70% of our population is dependent, like directly dependent on agriculture, right? The constituency of farmers in so many states is itself sufficient to decide who rules them, right? The farmers form like a big part of the electoral constituency, right? So imagine how important it would have been, the subject of whether agriculture is a state subject or a union subject. And even though agriculture and associated issues are actually spread out all over the three lists, we can say safely that dominantly agriculture is a part of the state list. How can we be so sure? Because there is an entry 14 in the state list that pretty much says agriculture. That's it, right? Agriculture, part of the state list, and then it sort of adds including agricultural education, research, protection, blah, blah, blah. But the verdict is clear. Entry 14, state. All right, that's the important bit. Then there are some interesting entries. For example, entry 26 that says the trade and commerce within the state, and this is a critical entry. All right, trade and commerce within the state is under state list. Entry 27, production, supply, and distribution of goods. Right. Important with respect, I just told you what those three laws are, right? So you can see the direct connection that there is, right? Production, supply, and distribution of goods, entry 27, state list. Markets and fairs, right? There's a legislation about agricultural markets. So markets and fairs, again, state list. And then there are a host of issues, right? Agricultural indebtedness, the land revenue, right? The estate taxes that come out of agriculture. The scheme of, even if this wasn't conclusive enough, the scheme sort of tells you that this agriculture is fairly, squarely within the realm of the state legislature, all right? However, let's zoom in on these two entries because that's where things get interesting, all right? So let's zoom in on these two entries, all right? So entry 26 says trade and commerce within the state and then subject to the provisions of entry 33 of list 3, right? So there is something very important in entry 33 of list 3. Like that itself tells you that's quite a story, all right? Similarly, for entry 27, production, supply and distribution of goods subject to the provisions of entry 33 of list 3. What is list 3? Concurrent list. A list on which both the union legislature as well as the state legislature could legislate, right? And if there is a conflict between the two laws, what would prevail? The union legislature's law would prevail to the extent of the contravention, right? So it definitely points you to entry 33, right? You must know what is the scheme here? Agriculture fairly and squarely state subject except entry 33 of the concurrent list. What does this say? Trade and commerce in and the production, supply and distribution of, leave the first part out, leave the A subsection out. Focus here, B. Foodstuffs, including edible oil, seeds and oils. And this part, right, foodstuff is where the game gets interesting. Entry 33 of concurrent list, I hope you remember what is the legislative procedure for that. Now, foodstuffs is the critical part. So, what this means is that trade and commerce and production, supply and distribution of foodstuffs is a subject on which the central government could also legislate. The union legislature could also legislate and the central executive could pass orders and administrative guidelines on, all right? So, let's compare that with industry. And that's an important bit, all right? Because industry ideally should also be a state subject, which it is. However, the rider, right? What does the entry 7 of union list say? That for the purpose of, it is necessary for the purpose of defense or for the prosecution of war, right? So it's the constitution, the list structure says that industry is within state list with a very strong rider that it could be within the powers of the union legislature for the prosecution of war or in an emergency situation, right? Or when parliament feels that it is expedient in public interest, entry 52 of union list. All right, not even concurrent. So it's fairly clear that even though industry falls within the realm of state, the union government could take over. All right, and that union government has taken over, right, in many legislations. But the verdict for agriculture is fairly simple. The entirety of agriculture is within the state list, and except this entry 33, there is nothing else in the list that gives the union government the power to legislate on agriculture. All right, so what is it? It's just this entry 33. And this is a critical part, all right? So scholars would say, or some of them do say, that the story of entry 33 is pretty much the story of India's recovery, right? Recovery from colonialism. Why do they say that? Because entry 33 has an interesting story associated with scarcity of food items in India, associated with famines in India, all right? Let's get to that, right? So under the 1935 Government of India Act, trade and commerce within the state and production, supply and distribution of goods was a provincial subject. All right, that's the important bit. It was a provincial subject. However, Second World War happened, right? And because of Second World War, there were conditions created where there was massive shortfall of food grains in many regions, right? So what the union government at that time thought expedient was that they needed powers to lift food from one part of the country and transport it to the other part of the country. Now, if this power, trade and commerce within state, was only restricted to the jurisdiction of the provincial governments, that union government could not do that. So union government used emergency powers to take over that domain of legislation. All right. So it became a union prerogative to legislate on this subject. All right. So even though emergency was then lifted in 1946, but as you know, you remember the Bengal famine, you know the date, like 1943 Bengal famine, 4 million people died. Those mini famines were still taking place in 1946. All right. In fact, let's leave that for now. Those mini famines were still taking place, right? So the government that was going to be formed, the Dominion government, right, under Jawaharlal Nehru from 1946, that was going to be formed, still had the problem of massive shortfall of food grains, right? So what would they do? They enacted this legislation, Essential Supplies Temporary Powers of 1946, because even under the 1935 constitution, this power, the subject was within the provincial legislature. So the Dominion government enacted a temporary law called the Essential Supplies Temporary Powers Act of 1946 to effectively handle the situation. All right. And another temporary article within the constitution was added, Article 369, that gave the union government the power to enact this law, right, from the state government for a period of 5 years. All right. So the idea was, okay, there is scarcity. Let's give union government the power to deal with this scarcity for 5 years. And then the power of the union government to legislate on supply and distribution of stuff, right, any stuff, would revert back to the states. Now, 1955 also came, right, and the situation is still bad, right? So there are some long lasting solutions that are needed, right? So the parliament got its act together and decided that they needed a constitutional amendment. All right. They needed what? A constitutional amendment. Why? Because alongside food scarcity at that time, if you read Hindi literature of that period, you'd figure that black marketing, hoarding, right, these traders scheming to keep prices high is like a common theme in that era's literature also, right? So that was a constant thing, right? So that's why the government, the central government, the Nehru government needed powers to deal with these elements and food scarcity, right? So came the third Constitutional Amendment Act in 1954. All right. What does this Constitutional Amendment Act do? It re-enacted entry 33 of the Constitution, of list 3 of the Constitution, right? So it enacted this entry, right? So this entry was enacted to deal with scarcity, giving central government the power to enact Essential Commodities Act. 1955. Now you understand the backdrop of Essential Commodities Act. Its precursor, right? So Essential Commodities Act comes to us from the Union government, because Union government acquired powers under the third amendment of the Constitution by inserting entry 33 into list 3. All right. So if you were asked to decipher the intent of the legislature behind doing this, right, you would simply say that it was a emergency measure that was designed to deal with the ever-present, right, scarcity in our country, right? That was the idea. And once you establish that intention, right, then you sort of become comfortable with it. All right. Yes, union government needed those powers, so we gave union government those powers. It's completely all right, right? That's where at least I found myself when I realized this backstory of entry 33. However, when you actually look at what was happening at the time, you'd realize that there was fierce opposition to this. All right, there was fierce opposition to this, led by some of the stalwarts of parliament at that time, right? Ashok Mehta, from the Ashok Mehta committee that dealt with local government, right? Ashok Mehta warned, all right, I want you to carefully look at the language here, that if the center truly wanted to control trade and commerce in states, then over time, he prophesied, it would also want to have control over crop planning and cultivation. He's saying center is going to go there, all right? Thus, the act would lead to an expanding encroachment on the rights of the states. He's worried about the rights of the states. A progressive erosion of state powers, all right, and the possibility of sidestepping of democratic processes, all right. So some would say he was very prescient about this, all right. Then there were multiple people who were raising serious concerns about this because they thought it would provide a toehold of the central government into the domains of the state legislature. Then there was KBasu, who was even more blunt. He said the passage of the act would transform the Indian constitution into a unitary constitution instead of a federal constitution and reduce all states to basically municipalities. All right, if you remove the powers of the state government, they really do turn into municipalities, right? In fact, later in the 70s, when the Sarkaria Commission was going around states and taking their views, the Tamil Nadu government raised this very strongly. They said that entry 33 is a serious encroachment into our domain, and we are actually losing money because of your entry 33. Right. West Bengal government also had a point to make about the same entry, and in its report, the Sarkaria Commission acknowledges this problem. All right, what does the Sarkaria Commission say? It says this act had disproportionately empowered the center in the management of agriculture. That is quite an interesting story, right? Or the story of entry 33. And it doesn't end there, right? Because in September 2020, this year, the government enacted these laws under entry 33 of the constitution, although the preamble for these laws does not mention entry 33, but it is widely believed because that's all there is that justifies these laws. All right. So the big question, right, is that do these laws actually infringe the federal principle, right? That's the question, and that's the question you could be asked, and that's the question that you should form an opinion on irrespective of preparing for an exam, right? So the Farmers Produce Act, what does it do? It takes control of the entire intrastate sale and purchase of all agricultural produce, which, as I told you, from entry 14, 26, 27, 28 of the state list is state's domain, right? Then there is a crowning section 6 of the same act that actually says to the states that you could not charge any market fee, cess, or any levy on trading of farm produce, which some would say is pretty decisive that the center has encroached. All right, that's the primary argument of the commentators when they're writing in journals and newspapers. They're saying, look at section 6, it's just blatantly violating. All right, so this forms a very strong case for the states, right? The states, when the matter goes to the Supreme Court, and this will become the bedrock of their argument. All right, so there's a constitutional question, there's a federalism question, right? Within the framework of the constitution, this is the federal question. You have 2 points that you can sort of think about or expand on. Then there is a financial, because fiscal federalism is also a thing, right? So then there's a financial question. In fact, these levies that this law is talking about, these levies cumulatively amount to quite a lot of money, right? For example, in Punjab, there is a 3% market fee, there's a 3% rural development fee, then there's an Artiya's commission, and it actually accumulates up to 8.5 to 9%, right? So if this law actually starts operating, Punjab government is estimated to lose 3,500 crore rupees worth of revenue, and Haryana government a similar 1,600 crore rupees worth of revenue, right? In fact, even though Haryana is the administration in Haryana is absorbing these legislations, not really openly in revolt, they are planning to seek compensation for the loss of revenue. All right, so you now have a federalism angle to this, you have a financial fiscal federalism sort of an angle to this, then there is the Article 32 angle, right? Human rights angle, right? So this, right, section 13 of the Produce Act, read this, right? It's beautiful. No suit, prosecution or any other legal proceeding shall lie against the central government or the state government or any officer of the central government or the state government or any other person in respect of anything which is in good faith, right? Good faith done or intended to be done under this act, or any rules or orders made under this act, right? So what does this mean? This means that if you're a central government employee or a state government employee, and if you're acting under this legislation, and if you have good faith, then you cannot approach, then no one can approach a court, a civil court against you. Right, that's sort of why that gives sovereign immunity. It has shades of sovereign immunity, right? So it gives a sort of blanket immunity to bureaucrats, right? That's I don't know if that's workable, right? The Supreme Court might look at this with a very stern perspective, right? So there is Article 30. So, for example, if a bureaucrat passes an order that violates your right to equality, right, that mistreats you or treats you differently from other without a rational nexus or an intelligible differential, then you are bound to go to the court and complain that your Article 14 is being violated, right? So that is going to be an interesting showdown there at the Supreme Court. Section 15 also pretty much says the same thing. So there is a human rights angle to this also, right? Part 3 angle to this. So there are parts of constitution like that are impacted by this. You should be acutely aware of that. All right. Now, what would the government argue? You should know that. All right. Because government's argument is also not like light, right? So government has a very strong economic argument. In fact, across the board, if there is one thing that is being accepted in circles, in newspaper circles, is that government does have a strong economic argument. Now, there are counter arguments. Yes, but right now the government has done a good job of communicating what they're saying, right? For example, the Swaminathan Commission itself, it came out with 5 reports in 2004 to 2005. The last 2 reports strongly advocated a common agricultural market for the country, although the methodology that it suggested is very different from the one that we're seeing now. Then there is the Ashok Dalwai, right? You remember a report that the government put in place to see if and how we can double farmers' income, right? Dalwai report. Even that report, for example, recommended one common agricultural market. Although the report said that we should add in the concurrent list a new entry that says agricultural markets. All right. So it was also implicitly agreeing that within the current constitutional framework, the government, the union legislature does not have the power to legislate on markets and fairs within the state domain, right? So it wanted a constitutional amendment. All right, that's what it wanted, as was done in 1955, right? However, that was not exactly possible, right? Because you'd need Rajya Sabha's approval for that, and Rajya Sabha is unlikely to approve a legislation like that at this political scenario, right? So, what the central government argument is constitutionally, besides the economic argument that I just told you about, is that it's not about federalism. It's about a farmer's choice. All right, farmer's choice to sell his produce to whomever he wants is a personal liberty issue. All right, the state governments restrict that choice within the confines of the area that they have notified within the APMC Act. They are enlivening that choice. They are bringing farmer's choice to life to provide him with options. All right, it's not a negation of states' interests in farmers' affairs. It's just an enrichment of farmers' choices. All right, that's the argument that the central government will make, besides a very strong economic argument. And where do they get the power to do it? The central government says entry 33, foodstuffs. It's mentioned there. That's it. Like, if it's mentioned there, then it's just mentioned there. They can legislate. There are no two ways to go about it. All right, that's what the central government would say. Then what do the courts say, right? So I would urge you to go and have a look at certain doctrines like doctrines of pith and substance, or doctrine of colorable legislation, right? So as it is in this case, the constitutional history of India, right, is studded with these cases where the union legislature and the state legislature have both legislated on the same subject. The union government arguing that this is within our purview, and the state government arguing the same, right? So the Supreme Court has had to come down and decide where does the domain lie, right? Who can legislate on this? In fact, that first case of 1962, state of West Bengal versus Union of India, was exactly that sort of a case, right? So I'm not going to go into those cases. In fact, there is a very interesting case called ITC Limited versus Agricultural Produce Market Committee. All right, 2002 case. The reason that this case is very important is because the facts of the case are just like ideal, right? They match almost ditto, right? They're the same facts almost, right? So the central government at one fine day in 1970s decided that tobacco is now within our domain. We are going to legislate on tobacco. All right. But there were legislations within every state about tobacco also, right? For example, Bihar was particularly interested in the revenue that they generate out of tobacco. All right. So the stately APMC Act of Bihar was levying a charge on tobacco production in their area. All right. So, in this case, the question was if the APMC in Bihar could charge a levy on ITC. Could they continue charging that levy was the primary question in this case, right? Very similar to the case scenarios that we have right now, right? And that similarity is what makes it like even interesting, right? So an earlier judgment had actually held the matter in favor of the union government, but the court in this case decided that enough is enough. It's clearly within the state government's domain. Let's just give let's ask central government to vacate the premises, right? To vacate the domain, right? So interestingly, the Supreme Court laid out some principles also. All right, the court said that the APMC, the Bihar APMC, could clearly levy a charge on tobacco. Why? Because the list 2 says so. All right. Then the court said that the state law will be nullified or will become repugnant only and only when both the central government and the state government have legislated on a matter enlisted in list 3, right? Only and only then would the state government's law become repugnant to the extent of the inconsistency or repugnancy. All right. And in those cases where there is a bit of a doubt, right? Where does this subject fall? What would the Supreme Court look at? It would look at where does the overall subject lie, right? And in this case, as I told you, entry 14 of the state list, the matter pretty much lies within the domain of state list, right? Entry 14, like clinching argument, right? So if you apply these rules, all right, to the current case, we would clearly have the state governments winning, right? So in this case, the Farm Acts of 2020, the applicable points are A and C. With regard to A, state could continue to charge mandi taxes from private markets anywhere in the notified area, regardless of the central act, right? So that is clear. So section 6 of the Farmers Produce Act is going to be precarious, right? Now, with regard to C, now as I told you, it's entry 14 dominantly within the state jurisdiction, all right? So it's only a speculation where this case is going to go, but you should be informed as to where this case might go, right? You should weigh arguments that both sides have and look at previous decisions and sort of make up your own mind as to where it should go, right? And it's just a speculation. We never know what's going to happen, right? There might be like new circumstances or new arguments or novel arguments that are made that actually clinch the day, all right? So what do we see in the immediate future? Supreme Court presumes constitutionality of a law, right? Whenever a law comes out of the union legislature, the assumption is that it's constitutional and only then it is tested on the touchstone of constitutional principles, right? So it's already constitutional, right? So, and the Supreme Court also does not stay laws, all right? It doesn't do that, right? For example, it did not stay the Citizenship Amendment Act or the UAPA Act, all right? So we are here for the long haul. We can see an interesting showdown taking place, all right? As I told you, there's an argument going around that the central government should have, in fact, amended the constitution, whether that was a better route, all right? So Ashok Dalwai, as I told you, had argued that the central government should have gone for an amendment of the constitution, and the fact that just because it says foodstuffs does not provide the union legislature with grounds sufficient enough to come out with these laws, right? So other commentators have argued that instead what the central government should have done is that it could have passed a special resolution as per Article 249. It could have made Rajya Sabha could have passed a special resolution under Article 249, which allows the central government to legislate on a matter enlisted within the state list if it is in national interest, all right? So that could have been a route that the central government could have taken, all right? However, the political scenario of Rajya Sabha right now makes that a little difficult to achieve, all right? So some would say central government just did not have any other choice, all right? So I hope this issue is clear to you by now. There's a lot of matter, there's a lot of content out there. You should be aware of the federal principles that come into play, all right? That should be your primary goal, and I hope you really get comfortable with that, all right? So then let's get a grip on this guy, all right? A grip on the issues that surround him right now. All right, he is obviously Amish Devgan, a lot of you must know. He is a news anchor. He has a program, I think, called R Par, all right? And it's the television show, the channel is News India, right? 18 India. Right, so what happened was that in July this year, Amish Devgan made some remarks about Khwaja Moinuddin Chishti. All right, these remarks were considered defamatory and derogatory. All right, so there were a bunch of FIRs filed all across the country. All right, and what these FIRs said was that he had defamed and this hate speech angle involved. There are different sections and different FIRs. All right, so Supreme Court, he goes under Article 32 and he says that please quash these FIRs, all right? So the Supreme Court had to decide whether these FIRs are maintainable or not, all right? And generally when Supreme Court decides that, it's never such a long judgment. But this one is 127 pages, all right? Just saying that the FIRs are maintainable, there is no, so the immediate relief has been granted. For example, he cannot be arrested and everything, but the FIRs are maintainable. That fact itself took Supreme Court 127 pages to impress upon us, and for good reason, all right, because that judgment is quite something, all right. If you're a fan of political theory, or if you like just dabble in that sort of stuff, then you should go through the judgment, all right. So, first and foremost, what does the Constitution say? We know there is a right to free speech and expression, right? Article 19, and that Article 19 is subject to restrictions such as sovereignty and integrity of state, security of state, right? So there are restrictions. So you are allowed to say whatever you want, but you have to keep in mind like a few things, right? So that's the message that the Constitution sends to a citizen, all right? Now, a word or two about this particular right, or theoretically, it's a peculiar right. Right to free speech has been recognized or widely acknowledged to be a rather peculiar right. Why? Because you could use the same right to diminish it. All right. So, for example, freedom of speech gives you the right to say whatever you want, but you could use that right to say wrong things about the existence of that very right. All right. So, it could be, this right could be the reason for its own demise, and that precariousness, right, is what makes this right unique. All right. That's why it is always, so theory always says that this right should be exercised with a lot of diligence among people, right? That's where the ideas of political community come in, right? A lot of political thinkers talk about the responsibility that comes along with the exercise of this right. All right, so what is the primary argument, right? It's almost dogmatic. It's right. It's a given in political theory that there should be right to free speech and expression, all right? But if you dig a little deeper, you would find out that the argument that is generally provided sort of like it's almost hegemonic, right? That right exists and you have to have that right. But the argument that is primarily provided for such a right comes from 200 years back, right? From John Stuart Mill, right? He provided the bedrock of why this right should exist, right? So according to the same argument, which was again then delivered by famously delivered by Oliver Wendell Holmes, is that world is a marketplace of ideas. All right, that's it. And there are bad ideas and there are good ideas. But you have to be faithful that eventually the good ideas will overcome the bad ideas and life would go on as normal, right? So the bad ideas would be pushed back, all right, in a ideal marketplace of ideas, all right? But that benign assumption comes under a lot of attack for very good reason, right? Hitler did come to power, so a bad idea did overtake a lot of good ideas, right? So, and this is just the basics of this theory, so I hope like you're grasping it. We're not going to get any more we're not going to go any more deeper into this, but you should understand the precariousness of this right, all right? And the reason why I want to communicate this to you is because this is where hate speech comes in, all right? So ideally, because we have a marketplace of idea, there are arguments coming in from all sides and there is a hot debate going on and everything. But this ideal scenario actually does not exist, right? Some voices are given more weight, other voices are sort of marginalized, and even then, the popular voices, even that is fine. But some voices enter into this marketplace where the intent is only to humiliate, offend, and that too because a person belongs to a certain community or belongs to a certain caste or religion, or he speaks a certain language, or wears, or like it's about the group, the identity of his group, right? And when that happens, that needs to be flagged. All right, whenever that sort of an argument comes into the public sphere, comes into the marketplace of ideas, that should be flagged. So there has been this consensus, right, building across the political community, that whenever that stream of language walks into, right, it should be highlighted when it happens, it should be penalized, and it should be discouraged. All right, now why? If, like, ideally, so you should just let it be, right? Ideally, the idea is that hateful speech should be overpowered by good speech, right? Like nice speech, right? That's the ideal, but that ideal doesn't work out. So we have evolved a political consensus now that hate speech needs to be flagged and prosecuted and discouraged. All right, so I hope you're clear on the theoretical part of it. And again, this is just the basics of it, right? This is skeleton. All right, so what about India? How do we deal with hate speech? In fact, you've watched that movie, right? A Million Ways to Die in the West. We have a million sections to criminalize hate speech in India, all right? And IPC is the primary one, all right? So the idea is not to know these sections or remember them. I'm just trying to make a point that there are a million ways to commit a hate speech crime in India, right? So for example, section 153 makes it an offense if you're promoting communal disharmony or feelings of hatred between different religions. If section 153A wasn't enough, we have a section 153B, right, of the Indian Penal Code that categorizes the offense of promoting religious, racist, linguistic, community or caste-based hatred or incites any religious. Right, so you get the sense, right? And then there is a section 298 of the IPC that says uttering words with a deliberate intent to wound the religious feeling of any person. All right, again, visualize it, a marketplace of ideas where there are arguments coming on from all sides, and in India also that's happening. And whenever there is someone making an argument that people of a certain religion are bad or are not good enough, right? As soon as that happens, someone can go to a police station and file an FIR under section 298, and that is flagged. All right, and then the court prosecutes it and then punishes the person who did that, and the message goes out in society that that's the wrong thing to do. All right, so you always move hate speech outside the public sphere. All right, so then there is a section 505 that criminalizes the act of delivering speeches that incite violence. So although it doesn't have to necessarily do with hate speech, but you could incite violence via hate speech. All right, so if that's why FIRs have multiple sections, right? So if that is not enough, this is put to use. Then if that was not enough, we have a section 123(3)(a) of the Representation of People's Act. That is one you would be good enough to remember. What does it do? It criminalizes hate speech by election candidates. All right, so you can see a million ways to die in the West. Then what happened was, in 2014, a PIL was filed in the Supreme Court about like asking the Supreme Court to do something about the increasing incidence of hate speech in elections, right, by candidates. All right, so what happened was an interesting story. All right, don't focus there. Like just listen to the story. All right, so Supreme Court basically said that we need to do more on hate speech. All right, the gamut of laws that we have in the IPC is not sufficient. This was an argument that was actually made by the government when it was enacting section 66A of the IT Act also. This was the same argument, the hate speech argument, that was made by the Kerala legislature, by the Kerala government when it promulgated that ordinance that criminalizes hate speech on internet forums. All right, so this is an argument that Supreme Court made, and it asked the Law Commission to think of sections that could be put in place to deal with hate speech. All right. However, it did not go beyond a certain point. It just asked law commission to do it. It also asked the center to take sufficient steps, but the principle was sort of consolidated there. All right. The Law Commission came out with report in its 267th report. It came out with 2 sections that the government should enact. It said we should have a section 153C, all right, that prohibits incitement to hatred, and like it criminalizes, and a section 505A that criminalizes causing fear, alarm, or propagation of violence in certain cases. All right. So the Law Commission has also added to that argument. Law Commission has said, yes, we need sections that deal with hate speech. These arguments that are walking into the public sphere, we need to flag them and we need to penalize them. All right. So Law Commission has agreed to that. Now, the Law Commission also dealt with another problem, which is defining hate speech. All right. How do you distinguish between an argument that is walking into the public sphere, that is all right, that does not cause harm, and some other argument that is actually hateful? All right. The Supreme Court asked the Law Commission to think of something, and the Law Commission said these parameters should be kept in mind: how extreme the speech is, was there an incitement, then the status of the author of the speech. For example, a 12-year-old child who is making an egregious claim about a particular community, you could assume is not really aware of the implications of what he's saying. And a person like Amish Devgan, who has millions of viewers, all right. Hindi news channels in India, like what they do is just insane, right? I sometimes think that the number of people who watch the commercial in like Hindi channels is the same as the number of people who watch English news channels, right? It's a massive audience, right? They pretty much dominate the Hindi heartland, all right? And that's his audience, right? So it's insane status associated with that guy, and so whatever comes out of his mouth, that is a factor that should be taken care of. Then like the status of victims, right? So it's a minority, right, in this case, so that would also aggravate the situation, and the context of the speech, right? The context of the speech is also important. Now, this is where Amish Devgan's lawyers, in this case that's happening right now, on which the Supreme Court delivered a verdict, the context of the speech, as the lawyers of Amish Devgan argued, was that it was the truth, right? Truth is a defense, right? But then the Supreme Court said history could be interpreted differently by different people, so you should be conversant with the fact that it's a very postmodernist argument that the Supreme Court made, that your truth is not necessarily the other guy's truth also, and even if you think that is your truth, then you should be careful about the way in which you communicate that truth to the people. Your speech was not saved by it being truth, all right? So in a 128-page judgment, the Supreme Court, basically in conjunction with the earlier 2014 judgment also, you should know 3 things, all right? And I seriously enjoyed reading that because I learned a lot, right? So for example, Supreme Court said that this hate speech, what hate speech does is that it brings into question your right to equality. Right now, it didn't come natural to me as to how is hate speech associated with equality. But Supreme Court is talking about this in a very identity-oriented manner. So the Supreme Court's argument is that whenever someone belittles a person by his association with a particular caste, community, religion, whatever, then essentially is saying that you are not, your identity, and by extension you are not on the same pedestal as I am. I am greater, right? I'm smarter, I'm better than you. And by implication, your community, your caste, your religion is not as good as my community, my caste, or my religion, right? Or the language that I speak, right? And that is why it impinges on your right to equality, right? So it's saying equality of identities is also a thing, right? So that is an interesting connection that you can write about, right? So it impinges on your right to equality, it impinges on your dignity, right, as an individual, right? So there is dignity involved, there is equality involved, and then what the Supreme Court says is that once these communities are sort of marginalized, right, their participation in the marketplace of ideas, or their wider participation into the electoral process, is hampered, right, because their voices are not given like adequate heed in the policy making circles. So the Supreme Court says that it's actually a democratic problem also, right? So it has to do, whenever there is hate speech involved, there are three things that happen, right? So what the Supreme Court said is that whenever there is hate speech involved, what happens is that your dignity, your individual dignity is at stake, your right to equality is at stake, and your democratic participation is at stake, right? So all these three principles enshrined in the preambles, right? So hate speech, according to Supreme Court, by extrapolation, is an attack on the principles enshrined in the preamble, right? And when you look at hate speech from that perspective, then you sort of start looking at it as a serious problem, right? Then there are other questions also, right? The identification of hate speech is a big issue that could be misused, right? So for example, state could enact laws that say your speech as insignificant or as normal as it is could be hate speech, right? So people could be targeted by the state using hate speech laws, right? So that aspect of it, you don't need to like worry about too much for now, right? So that pretty much was the core of Supreme Court's argument. It said that all the other types of arguments that are coming into this marketplace of ideas have a redeeming quality that they actually add to the debate, right? Good ideas would prevail. So hate speech has no redeeming quality. Why? Because the very intent of that speech, right? The very intent of that speech is to belittle a person's community or his identity, right? So as to the standards of it, that's a very legal question. So the standard, there was a famous Jagjeevan Ram case where the Supreme Court said that there should be a connection between what has been said and the potential threat to the community, all right? And then in another case, the Supreme Court said then when it comes to hate speech, the standard should be that of a regular courageous person, all right? Not of a person with a small heart, all right? So that is pretty much sums up the idea here. There's another argument that it's an ancillary argument that the Supreme Court made, that whenever in this marketplace of ideas there are arguments coming that criticize the government, that should be dealt with more leniently, right? The standard for hate speech there is pretty high, but whenever it's against an identity, then that's a direct issue, all right? So that pretty much sums it up. I really hope now you can write a good answer on both the federalism aspect associated with these farm laws and the hate speech dimension, all right? It's very complicated. I've tried to sort of simplify it down, try to make it more appealing. I hope that worked. To continue to read newspapers, continue to be engaged with the political conversation around you. All right. So thank you so much for listening. Put your questions and comments. I'll try and answer them. Thank you so much for listening. Bye-bye.